my presentation is a little different than my colleagues, only in that I'm going to call on you because we'll be talking about a lot of what could be real-life examples. And I think it's helpful for everybody to kind of think through the scenarios that we'll get to and contribute together, because I think we learn more when we collectively work through the problems. So just be forewarned, we will call on you, and we have somebody with a microphone that will be coming around to help get your voices amplified. So with that said, I am going to start. The Texas Ethics Commission really is an organization that really was started to deal with state officers and employees, but they have morphed a little bit into the local governmental realm. But they have some should nots that they put out in a pamphlet that they publicize, which I recommend to all of you. All of their publications are online. And I always like the should nots because as lawyers, we're always asked, well, can I do this? Can I do this? And you know, this is one of the first places I go to as a resource. I mean, certainly you're going to go to the law, but you also like to know what the Ethics Commission is thinking. So this is my shortened version of their should nots. It's basically you can't take gifts that are going to influence your decision. You can't take employment or other business opportunities that could require you to disclose confidential information you get as a result of being a trustee or a regent. You cannot accept other employment or compensation that can impair your independence of judgment, cannot make personal investments that could create a conflict with public obligations, or intentionally or knowingly accept or solicit a benefit for having exercised official duties. I know that none of you would do those things, and that should never come up for you, but I will tell you, in the 30 years now that I've been practicing, those issues all are good fodder for lawsuits that my colleagues and I have all seen and read, if not dealt with. One of the big issues for trustees and regents really relates to procurement and contracting, and that's one of the areas where the legislature has been actively involved in the last couple of sessions, and areas where ethical issues will arise for you. For state institutions, it's kind of a cannot, as opposed to trustees, local governmental institutions, it's more reporting, a transparency of potential conflicts. But on the state side, it's very clear rules of should not. And here, I've kind of outlined it for you. Members of a governing body, including the executive director, general counsel, chief procurement officer, or procurement director of the university, family members related to all of these people, cannot have a financial interest of at least 1% in the vendor and do business with them. Now, there's been a lot of discussion because there's two competing laws in Texas that relate to this very specific thing. Yeah. My opinion, and some lawyers across the state may disagree with me, would go with a lesser standard of 10% in a different provision of the law. This statute that I've cited here is the more current law, and this is the one that, is my opinion, is the one that's applicable, and the Attorney General has issued an opinion that agrees with that. So you ask, what is a financial interest? It's the 1%. You can't have some financial benefit to the employee or official. These are all the family members that apply for contracting and procurement, which is incredibly extensive. So as I explained to my colleagues, I had to do an FBI check this year. My father, who's long deceased, was married to a woman after my parents, after I was long grown. I had to disclose to the FBI every person that my stepmother's children had ever been married to. These are people I did not grow up with, did not have a long-term relationship with, but I had to know all these things. This procurement law is very similar to that. Like, how in the world am I going to know what business interests my spouse's grandchildren would have, or my stepdaughter or stepmother, stepfather? It's complicated. This is another provision of the statute, which is really more like a revolving door statute. So if you were engaged in agreeing to this contract, you cannot then go leave the university or leave your role and go work for that vendor. House Bill 23, that was Senate Bill 20, that was from last session. House Bill 23 is the local governmental side. And this is similar to Senate Bill 20, but not a duplicate. And it too is about more disclosure in the contracting function. But it differs greatly from my point of view in that it really just requires disclosure of those conflicts or potential conflicts that an employee or a trustee could have with a potential vendor, and has very specific requirements. If you could have received $2,500 in the previous 12 months, that is the benefit, or a gift of more than $100. This would be something you would have to disclose. The forms are all on the Ethics Commission website, both filled out by the potential trustee that could have a conflict as well as by the vendor. Again, more definitions of family members. It's different for gifts than it is for procurement. Just something you need to be aware of. Again, very extensive, as you can see, all the different ramifications that could come into play. It's something you should, if you have a potential procurement, and your universities and colleges should have processes set up to ask questions of the vendors with regard to these relationships, but it's something that you as trustees and regents should be aware of. So that gets us to our hypotheticals. So here's our first one. You have a regent who owns 1% in stock of a national office supply company which regularly supplies to the university or college. Is that can the university continue to do business with that office supply chain? They've been doing business with this office supply chain for, let's say, 30 years. And then the regent comes on board, they go up for bid. Can the university do business with this vendor any longer?
Yes, you can continue to do business with them because it's a prior relationship.
Does it matter if that relationship, if they're going out for bid again, and, well, what do you guys think?
If they're going out for bid again, they just have to disclose it.
That's on the trustee side. What about on the university side? Regent McKelvey, you're going to have to answer because nobody's answering for me. I know he will.
You have a plant in the audience?
Yeah, I do. He's right there. One of my board members is here. Oh, here we go. I know, I told him, I warned him ahead of time.
Oh, you.
So if it's a regent, we have an answer on a trustee side, it would have to be disclosed, and that's correct. If it was on the university side, so the law is a little different. Could the university, going out for bid again, continue to do business with that office supply company where one of our board members owned 1% or more of that company?
I would think the university could go out for bid as long as the regent recused himself, was completely not involved in any discussion of the contract.
What do you guys think? Kavi?
I'm going to defer to the four-year experts.
Fernando?
I know the
Well,
answer for
Senate
community
Bill
colleges.
20 is very restrictive. There's some language in there that says that that the board cannot enter into a contract. And we're looking for clarification right now from the Attorney General's office, and because your regent is correct, under the education code, which many of us can go under, all you have to do is disclose and recuse yourself from voting and participation. So I'm not sure I know the answer to that.
I think
It's a definite maybe.
it's a definite maybe, but I will tell you that if I were going to give advice today based on the recent Attorney General opinion, as the law is evolving and as muddy as Senate Bill 20 was, I would tell you that no, we could not continue, we could not do business with that particular vendor. That would be my opinion.
Conservative advice, it's always good.
Does it matter if the regent buys that stock after the purchasing contract is signed with the university or college? And I'll refer you back, I'm going to give you the answer a little bit ahead of time. I'm going to refer you back to the should nots, which is make personal investments that could create a conflict with public obligations. So do you think that helps you answer the question?
Yeah, that last language is from existing law. It's not in Senate Bill 20. That's in the Government Code 572, which is an obligation that board members have not to engage in business or professional activities that could cause a conflict. So if he bought afterwards, then he certainly was knowing, as opposed to if he came on the board with the interest.
Okay.
So it's safest not to do it.
I would think so. You are approached by an alum who's also an architect. He wants you to help him in his bid to land a major university project. What is your appropriate role? Who wants to help me with the answer to this question?
This is your university or?
Yes, yes. How would you answer the question?
And you have a microphone now.
There you go.
Well, I make no pretense to being an attorney, but
You don't have to be.
it certainly doesn't pass the smell test.
Which goes back to Fernando's comment at the beginning when we start talking about ethics. Does it feel right?
Right.
So the way I would advise a regent or a trustee is always defer to the process. So you're all going to have very specific procurement processes, and you really need to let those processes take its course. I think the role for a trustee or a regent in that situation would be to make sure that the alum is aware of how they can get engaged in that process, and then really just step back and let the process take its course. And you really don't want to do anything that would lead you to interfere in the process. So in any kind of procurement decision, the best advice is always to let that process take its course.
Let me add something.
Go ahead.
Letting the process take its course avoids is an appearance of impropriety by the university general counsel or other university official. And I personally counsel our board members and other employees to always strive to avoid even an appearance of impropriety, because newspapers love to deal with potential improprieties as well as real improprieties.
So the second question I have here is, if a local service vendor wants you to provide an introduction so they can pitch a sole source contract or get a preference, obviously a preference would be inappropriate. That's kind of obvious. But what about just can you give me an introduction so I can pitch a sole source contract? What do you think, Bill?
I would be leery of it for the same reason I just mentioned. It, again, or to use this gentleman's language, there's a little problem with the smell test there. It's a sole source contract, and that's what this particular vendor is seeking. And in my position, were I to give them an introduction, it may carry more weight than it really should. And that would be my concern.
Yes, sir.
I've run into this exact situation in a previous board that I served on, K-12 school board. And I guess the way I dealt with it was to tell them, and I think it's the actual truth, that the staff resents that kind of interference from a board member. And were I to do such a thing on their behalf, it would probably harm their ability to get business rather than help it. Therefore, I'll do them a favor and not get involved.
It's a gracious way to go about it.
I think that's accurate. Here we have a regent who has recommended her best friend, an architect, for the construction of a new dorm that's planned on campus. And secondly, or alternatively, a regent recommends the granddaughter's husband, whom she doesn't like, as the architect. What should your role be on voting on the project? So you're not actually doing anything. I know this person, this is one of my best friends. You're discussing this in open session. This is a great architect. What would your role be in voting on the project?
Anyone?
Any takers? Cobby? Bill?
I think
Fernando?
yeah, go ahead, Fernando.
Oh, well, if this person really is your best friend, and we're not talking a Senate Bill 20 issue, this is something different. I guess your regent, Mr. McKelvey,
Yes.
he talked a while ago about making disclosure, and what you do is you make disclosure, and then you don't comment any further, and you recuse yourself from the deliberation discussion. In fact, we have a rule that goes a little bit beyond what the state ethics code goes, and we require the regent to leave the room because, again, if it's going to be your friend, you've engaged in a business or professional activity that splits your loyalties here. You have a public interest, and the public interest is what's best for the institution, but you also have a personal interest. And the law says that you cannot engage in a business or professional activity in which you are advancing the interests of somebody else. It's not only a conflict where you're concerned, but you are advancing somebody else's interests. So you make if you want to make the recommendation, which I'd feel uncomfortable with making if I were on the board, but assuming that you wanted to make the recommendation, then you just need to bow out of it, and wouldn't hurt to say to your fellow regents, look, I'm not saying you must, I'm telling you, you judge on your own and make your own decision. But a lot of those decisions, even the hiring of architects to compound the issue or to make it more complicated, it's not only about the board involvement. It's oftentimes about the involvement of the institution, because at least in our system, that's where the architects are hired in the first place. So.
Yes, Regent McKelvey?
I guess, when I saw this one, it looks a little different because there appear to be two separate actions. There appear to be two separate actions here. One is just the action of constructing or voting on the building of a dorm. And then there's a second action related to the regent perhaps not following the correct procedure as it relates to the recommendation of vendors or service providers who may well work on the dorm. I would think that once the regent can vote on the dorm, but I would think that at that point, the regent should not be recommending. That action to recommend someone specifically for a project that they voted on could be violation of the law.
It certainly could have the appearance of impropriety. It certainly could.
What about the granddaughter's husband? Is that outside the second degree of consanguinity and affinity?
Actually, I don't think so. think
I,
it's
I was trying to do it
within.
in my head, and I don't have those charts
No, I
memorized.
actually think it is within.
Yeah.
So I don't think it would change the answer.
It certainly is on the community college side, because that's a third degree, I think. Third degree of consanguinity and second degree of affinity.
Definitely covered there.
Yeah.
My advice would, again, you know, and it's different because board members, as Regent McKelvey points out, may vote on the project but not on the particular vendor. And that varies from institution to institution. There's not one answer for that. In our institution, a board member would not be in the position of actually voting on a particular architect, and that would be delegated down. But a regent's opinion, as my colleagues have pointed out, their opinion and their recommendations can have more weight than you realize. As Fernando said, the Diet Dr. Pepper in the airplane, I mean, that's something a procurement officer might give more deference than is appropriate. So the best advice I would give you is it's probably better not to make a recommendation to begin with.
Donna, I've also got a rule for that that may help you in terms of where you draw the line. Ask yourself whether your decision or your action falls within somebody's job description. Like the choosing of an architect. Does that fall within the job description of somebody that works for you, as opposed to something that really is a board decision to make?
Agreed. I like this one. This is a new one this year. You have received a call from an unhappy vendor whose company missed the bidding deadline by 15 minutes. You have reason to believe this vendor is the most qualified and could create significant savings for your institution. What do you do?
Good.
That is absolutely one answer. Any other thoughts?
If you really believe that this vendor could create significant savings for your university, do you have an obligation to act on that belief, basically blow up the bidding process and start it all over again in the hopes that this vendor can be on time the next time?
Exercising your fiduciary obligations to the institution. Does that trump the duty of, or the?
Avoiding the
Avoiding
appearance.
your conflict of interest?
I would suggest that you have to take a long-term view on this, that you may have some short-term gain if this vendor is brought in, but in the long term, you've corrupted the process and encouraged people to continue to contest the way the rules are written. I mean, if 15 minutes, why not 30? If 30, why not an hour? If an hour, why not a day?
Yeah.
No, we're very strict on our I mean, if it says those bids need to be in at 3 PM and they're in at 3:10, that bid is not accepted.
Right.
It's just the process, as I say, defer back to the process. I don't think this has one absolute answer, though, because if there, let's say you're talking about a savings of $1 million, is it absolutely incorrect to at least consider going out for bid again to save the institution $1 million, for example?
I think that's a legitimate position for the staff to take, but I don't know that it should be at the behest of one
But
of
if the
elected or
region is the
appointed.
one that is aware of the information and brings it to the staff, and then the staff can make the decision on whether or not it's accurate information and whether it's in the best interest of the institution to go out for bid again.
Yeah, I think if you have the relationship with your staff where you can make suggestions like that and they don't automatically just do it because of who you are, but they, if it's really their determination that this is the way to go, I guess that's, I don't think it violates the law necessarily.
But it's beginning to sound like you're advocating
Yeah.
We're advocating meddling. I mean, I just heard Fernando say that if you're taking an action that sounds to be within someone else's job description, you should probably defer. And this sure sounds like meddling for a regent to step in 15 minutes after a bidding deadline and say, hey, wait a minute, stop what you're doing, because here's a vendor who might be able to save us a lot of money. I mean, I think at that point, it's too late.
How about asking your general counsel? Every school has a general counsel there, and say, okay. Shouldn't general counsel be available if the agent has a question?
Of course, of course.
So instead of making your own decision, just ask the general counsel.
That's the answer.
That's if you agree.
Is that a safe process?
Right. It does help. Yeah.
No, I,
Defer to someone else whose job it is to advise on the issue of, is it correct under your processes to allow something to be rebid? Do your processes allow for that particular situation?
No, I have a question here. I'm founding chairman of our chamber, U.S. India Chamber of Commerce. Every year we have an annual event and the letters go out, which is signed by the current chair, myself, and the chair-elect. So if a letter is going to UNT, should my name can still be there, or I should ask them take my name out?
So this is, what is it asking the university to do?
It's basically sponsorship for the banquet, membership for the chamber.
You'd be safest to take your name off of it.
Yeah. That would be the safe
I
thing to
just sent
do.
a text message to my chairman saying, any correspondence with UNT, my name shouldn't be there.
That would be the appropriate
So-
Yeah,
response.
I think that's the cleanest way to deal with it.
Yep.
It's, even though they have been doing it before even I became a regent, so.
Yeah.
But, yeah, no, I just sent a text message, take my name off.
Yes, Mr. Nancy.
I think it's fair to say that most governing bodies allow for the rejection of all bids in a situation where none of the prices are deemed to be acceptable. But that's almost always, in my experience, tied to a rewriting of specs in order to hopefully gain better bids. I'm hard pressed to think of a time I've seen a rebid in any situation other than that.
Agreed. Yes, ma'am.
Yes, Sheila Stearns from Montana. So it's not a Texas example, but this has brought to mind an incident early in my career in the 80s when I was a vice president. And I have new respect, thinking back, for the trustees who supported me. But we had the long-established bus company that served all of our universities in a certain region, especially the athletic teams, huge donor, definitely had probably the lower bid, and they came in about a few hours late. And the upstart company from down the valley had never made any donations, got theirs in on time. And I just said, when they came to me first, said, I'm sorry, we can't. The procurement officer was looking at me like, what are you gonna do on this? Vice President Stearns, and there was no question in my mind, and it was really hard. They were, but when I think back on it, finally, after a few days of contacting board members, trustees, everyone they could, the president of the bus company called and wrote to me and said, we wish you could have, gone the other way, but we respect it. We'll have our bid in on time next year. That was a good reaction.
Ultimately, process is your friend, so
Correct.
you're never wrong to just rely on the process.
That's exactly right. So you're invited by the president of one of the campuses to visit the campus and meet with officials or donors interested in donating land for the campus. What is your proper role in that situation?
Remember, you're looking out for the best interests of your institution.
I think it's really,
When you say officials, though, you're just talking about someone else.
yes, yes. I would say that in this situation, because you're going to, as a regent or a trustee, you will be put in situations which are not the typical ones that you would generally be dealing with. And this is more one of your relationship, you have all been selected based in large part about your relationships and the experience that you bring to the role as trustee and regent. And the president is appropriate for her to ask you or him to ask you to participate. But remember what your role is. It is one that you defer to the president, and you are there just as a representative of the board, but you cannot speak for the entire board. You are there more in your political role, so to speak, as opposed to a role of accepting a gift, which typically in a donation of a land would be something that would have to be evaluated, because in my experience, not every piece of property is one that a university might want.
Well, Donna, I think this goes to the relationship between the board and the individual board member and the administration or the president. It would not be inappropriate ahead of time to ask the president, well, how is it that I can help you? Do you know somebody there? Are you in the same profession? If a realtor is involved and that's what you happen to have done most of your career, there's a lot of reasons and a lot of contributions, but Donna is right. You defer to the president, but get some guidance and then speak, but speak cautiously, and remember that you don't have authority to bind the board, and that it has to come back to the board. But you could be very valuable in that role, and I've seen it, and it's very useful when a regent or trustee is involved. But be very circumspect.
You get a call from a friend asking you to intervene on behalf of the daughter who is seeking admission to the university, but may not have the qualifications. How do you respond?
I was excited some comment last year.
I'm sure this has never occurred and never will occur for any of you, and I get asked this question all the time. So what can I do? And you will get probably 4 a little bit different answers from all of us. Some will say that it could have the appearance of impropriety to write any letter. If you had, and to me it would really depend on the situation. I recall a regent saying, I've known this child since she was in diapers. I have been best friends with the father for 30 years, 20, 30 years. And I know this would be a fabulous person at your institution and more than capable. Can I do anything? And of course they ask me, and there's no good answer to the question. And the way I answered is, number one, I think as an individual, it's very difficult once you become a regent or a trustee to have any role other than as a regent or trustee. It's almost impossible to step back into your shoes of, I'm not a regent or trustee, I'm going to write a letter individually on something that impacts your institution. I would say that's almost impossible. Maybe you could write a letter that, not as a regent, but just as I've been best friends with this family and I know this young woman and blah, blah, blah. She's fabulous for whatever reasons there are. Maybe you could write that letter. There are others, and as the world evolves, that may be how I would have answered the question, 10 years ago. I'm not sure I would answer that question the same way today. It's just, we are living in a world of hyper attention to the appearance of impropriety, and most would argue that it would be inappropriate for you to write that letter. I think in this day and age.
I know a couple of clients of mine have trustee codes of ethics, and in at least one of them, I think maybe more than one, they have a provision that says that the trustee cannot do anything to try to influence a college employee in the conduct of their duties. So even saying, well, I'll take trustee off the signature line, you're still trying to influence a decision, and that would be wrong. And that really flows from the SAC standards that, SAC doesn't want any kind of meddling, as was said. So to really just keep that completely out of line.
And I don't think if the call comes from a legislator on behalf of his daughter, I don't think it changes the answer to the question. I appreciate that.
Tell them to call the president.
Call the president, yeah. That's a good answer. I don't think it changes it. Never would occur. You get a call from the governor's office insisting you vote against any tuition increase because the governor is concerned it will hurt his reelection bid. How do you handle this?
Oh, Lord.
Well, you deliberate with your board, make decisions based on the best interests of the institution, and leave it at that. I don't think there's any other way. Deliberate with your board, consider all the reasons why you should be discussing whether there should be a tuition increase or not, and make your decisions in the best interest of your institution. I don't think there's any other answer for that. Fernando?
No. Ultimately, you're there to act and deliberate as a board, and it's your judgment what's in the best interest, your collective judgment.
And I think that goes to what you were talking about earlier, Fernando, about independence as well. Your loyalty and duty is to the institution, not to the appointing person.
Correct. You have an idea for a new academic program. You want to promote it. You have all these fabulous ideas, about this academic program. You can even imagine who could be involved in it, and faculty lines and startup packages, and oh my goodness, it would be fabulous for our community. What are the problems created here? What would be the way to actually, if you have this idea, what is your role? You're a policy-making body as opposed to an operational body. What do
You
you,
shouldn't have approached the dean, you should have approached the president.
go to the president? What do you think, Fernando?
Well, again, this brings me back to my job description thing. Are you engaging in an action or a decision that really would fall within somebody's job description? Now, how we make rules and how we make policies, it, boils up from the campus level. Academic matters are generally, and curricular matters are generally within the purview of the faculty. So I would probably have a discussion with the provost, president, and say, gee, this has occurred to me. If this is something you'd like to run with, I think it would be wonderful. If it's not, then you need to leave it alone. And it may be the best idea in the world, but maybe that's not where they want to go. We had a chancellor, not this one, but a former chancellor that wanted very dearly to create a center for ethics on one of the campuses. In fact, even donated some money for that purpose. Went to visit with the president and members of the administration. They said, well, gee, Chancellor, we really are interested in a center on American civilization. That's what the faculty wants, and that's really kind of the direction we're going. We'll take your money if you want to give it, but but really that's the direction we're going.
You always got to get that in.
And he did give them, to his credit, he gave them the money, and they continued with their program, and that was that. But you know, the chancellor there was in the same role as a regent. You have to let these institutions do what they do. These are professionals. These are faculty. These are people that have a much better understanding than regents or trustees, and even general counsel. And so you bring it up and then you let it go if that's what you must do.
I'm going to skip over a couple of questions here, but I will tell you, if you have questions about any of the hypotheticals that are in the slides, I'm happy to respond to emails, as will my colleagues be. I'm just going to run to the very last hypothetical I had, just because this raises a different point. You will be approached from time to time for people who are concerned about issues going on with their employment, whether it be some grievance they have, or they're maybe not getting tenure, or they're about to be fired. Just remember that that is not something, again, as Fernando says, that's going to be somebody else's job. But ultimately, especially in a tenure matter, that can be your job. Those decisions are ultimately made by the board, and speaking to anybody involved in the process about something that could ultimately come to you would be inappropriate. So with that, I'm going to stop because I know I'm overstayed my welcome, and
not at all.
turn it back to Bill.
Great job. I would like to say thank you to Fernando, to Donna, and to Kabi for this year's presentation. And once again, I think they've done an outstanding job, and I'd ask you to join me in showing our appreciation. And I thank you for your participation. And I realize this is a long session, and it deals with, at times at least, some dry material. So thank you as well. I hope you got something out of it. Stuart. Yes, sir.
It's hard to say no.
Well, and I thought Bill Franz was strict. Oh my gosh. Okay, so Kevin Riley had an idea. This is an open meetings issue. We're talking about management of the board, and the chair in particular. And he said at the University of Wisconsin, they had a practice where the chairman, the vice chairman, and the chancellor would each call before a board meeting 3 of the 9 board members. I guess there were 12, I don't know. And then sort of talk about sort of issues and concerns. And then they would meet, and you might have to, but that's kind of the gist of what you had said. And that way, the chairman and the vice chair and the chancellor would have a sense of the board. But I asked him if it would violate Texas open meeting laws, and he said, I don't know.
So let me, do you want to restate?
No, that's fair, except there were 18 board members, so it was a lot more work every meeting, but.
So how many board members ended up being contacted by this trio of officials?
So each of us, each month, we would divide the board into thirds, and each of us would call the third to which we were assigned individually. So I would have individual phone conversations with a third of the board every month. The chair of the board would do that with another third, the vice chair would do that with another third, and then for the next meeting, we would rotate the thirds.
And so what you basically are doing is covering the material, the agenda for the upcoming meeting, and discussing views on whether or not we should vote up or down, strategies for how to move an issue forward, if we want to move it forward. Is that the gist of it?
No, honestly, typically they were not that strategic. It was more in the context of saying to board members, do you have any questions? Can we help you understand the materials better. It was rarely, in my experience, saying, we want you to vote this way, or how are you going to vote? Can I slap you on the back or dissuade you? And the purpose of it really was to make all the board feel like they were involved and their opinions mattered to the chair and the vice chair and me before they had to go in and talk about the big policy issues.
My concern with that approach is there's a case out of San Antonio, I don't remember, maybe 10 or 12 years ago, that ultimately resulted in the term a walking quorum being created. And what happened there was different members of the San Antonio City Council would talk with other members of the city council, and they divided it up strategically, so that at the end of the day, or the end of the week, whatever the time frame, pretty much everybody on the city council had been contacted by at least one other member on the council to discuss the issues. And the court looked askance at that, coined the term a walking quorum, and found it to be violative of the Open Meetings Act. That would be my concern with the approach you've just mentioned, but let me turn it over to my colleagues.
So-
And Donna?
Yeah, the concern I have with that process is that it's being run by other board members. I'm comfortable if you had an administrator call and speak to a regent about what's coming up, but I am uncomfortable with it when it is other board members doing it for the same reasons of the walking quorum. And if there's more than one regent, you've got to be having that conversation. You've got to make sure you don't have a quorum of any of those committees or a quorum of.
No, there was
of the
never
board.
more than
Right.
one region.
And so, and in addition, you should never be discussing, in Bill's example, how you might vote. But I think it is appropriate for effective board meetings to have discussion from time to time about what's coming up on the agenda. It makes for a more effective board meeting.
The other thing is, the regions that are being talked to, if it's not all of them, what happens, or the trustees, if they in turn go talk to other trustees or to other regions? You may have the full board engaged in an issue well ahead of time. That's the first thing. Second comment is, if you do so via text or email, again, Kabi, I'm sure, will tell you that's going to be subject to, even if it's on a personal, on personal equipment of each of you, you're still conducting private business, and we've heard a lot of that. I'm not making a partisan statement politically, but we hear a lot about business being transacted over private email servers, and that's exactly what they're talking about. If you want folks engaged and involved, the thing that would help us most, I think, as an administration of a system or of a university, is you read the materials that we send you. If you have any questions, you work with the committees that you're assigned to, call the appropriate vice chancellors, call the chancellor, and that's how you become engaged and involved and knowledgeable about what is going to come up at the board meeting.
Yeah, I'd be worried about a couple of things with that. The walking quorum is certainly the biggest, and remember the definition of a meeting is a deliberation between a quorum, and once you've created the notion of a serial meeting or a daisy chain meeting, you're discussing public business, which is deliberation, and a majority of the board is ultimately involved in the conversation. So you might be able to prevail. There's very few of these go to the courts of appeals, so there's not a lot of guidance we can get from there, but you might be able to convince a jury that we're not intending to violate the law, we're just trying to answer questions. But it seems really risky to me, and you could just as easily end up being convicted. So, I mean, the way it should be done is by staff. And, the trustees or regents just need to know if I'm confused about something or I want more information on it than I got, don't go talk to other trustees or regents, go talk to as Fernando said, the people involved.
I guess I'm having trouble understanding why this would be a close call. The TOMA very explicitly says, if you meet in groups smaller than four, where the effect of those meetings is to create deliberation among a quorum, that's a violation of TOMA. It's just,
It's for the intent
the
of
one.
the,
That's what
of the
the
separate
four of
meetings.
us
I
all
don't think it would.
tried to convey.
Yeah. But there have been weird outcomes in open meetings,
walking
criminal
quorum is a
prosecutions. I'll give you an example. In Upshur County, I can't remember which school district it was, but one of the school districts up there, they were having problems with their superintendent. The board president, over the weekend, basically got the superintendent to lay out the terms on which he would resign. She then contacted all the other trustees solely to say, he's given me his terms. Do you want to have a meeting, as soon as possible to talk about that, or wait till a regular meeting? And they all said, let's have a meeting. So they had a meeting about it. They bought him out. He moved on. They all got prosecuted by the county attorney up there. And ultimately, they were not convicted because the jury said it's too confusing as to what is or isn't this kind of walking quorum concept. But, they went all the way through the criminal trial process to receive that sort of indication. And it seemed like that doesn't seem like a very close call, because you can contact each other to talk about scheduling things. But they prosecuted nonetheless, so.
So just to clarify, the laws you're talking about are Texas laws.
Texas laws, yes.
Oh, yes.
Yeah.
I didn't want to go home and tell my colleagues in Wisconsin they were going to jail.
But
Right.
but-
So basically, the answer is no.
Yes, we're addressing Texas law.
But that's why I was going back to the definition, which is a Texas definition
that's what I
of the
figured,
deliberation is. And as to the criminal thing, you have to have an intent to try to avoid the law, and that again would get into a question of what's your mental state.
And that's why I told Stuart I couldn't answer his question about whether he could do it here. But let me bring up a larger frame, which I think is really important. I'm all in favor of freedom of information and open meetings laws in public institutions. I think they really serve democracy. But I think in instances maybe like this one, where if we're interpreting the laws to mean no trustee can have a conversation with another trustee about an upcoming issue on a meeting agenda without the fear that that could be accused of being a walking agenda. I don't know if you're going quite that far, or is it that
Not one
No.
talking to one other,
No,
one
that's-
talking?
unless there's only three on the board or
Okay.
commission.
Where do you draw the line? If one talks to three?
That would be wrong.
Yeah.
Two?
Well, it
Here's-
depends on what a quorum is.
Yeah, it
That-
depends on your
Right.
quorum, but what
Of a committee.
the rule I have, since I, sometimes put on a hat of an elected official, is I usually try to have another member of the council that I can bounce ideas off of, just so that, I know I'm not all alone in these ideas. But we have a blood oath that we don't talk to anybody else about it, because the concern is you go talk to that one, you get some feedback, and that one goes and talks to somebody else, and you're like, I didn't really get very far, let me go talk to somebody else about it. And suddenly you've roped in a quorum and you've talked about it. So it is difficult, and a lot of people are taking the position of, outside of a meeting, I'm not talking to any of you.
Right.
That's probably too far, but it's not, the line is pretty close.
There was recently another court decision that I think addresses the concern you have. I'm not sure you'll like the way it addressed it, however. But what happened was a group of local officials essentially decided to challenge the Open Meetings Act and brought a lawsuit challenging the constitutionality of the act, particularly as applied to them. And it went through a federal district court and ultimately to the Fifth Circuit Court of Appeals, and they lost. And so the Texas Open Meetings Act was upheld, and yes, it is very strict, and it carries, as Cobby has noted, certain criminal penalties in certain instances, but it's the law of the state.
Got to follow it. My only bigger concern is this. I think boards work or don't to a large extent on the trust that the members of the board create among each other.
Certainly.
And if we're being told that the current interpretation of the law here or anywhere is board members really, to be really safe, just shouldn't talk to each other at any time outside of the public. Well, that's what I'm hearing a little bit from Cobby. Outside of the public meeting, I think that's not healthy, and I think, let's talk about the nature of public meetings. They are, to an extent, theater. And people come in, and people on boards may want to take public positions in certain ways because they're sending messages to constituents and others. If we can't have some ability for individuals to talk to each other beforehand so they at least know why a colleague is taking a
You know,
position.
nobody's saying you can't talk to each other. We have a committee structure, and a lot of the systems and universities have committee structures. You have a finance committee, you have an academic committee. Generally, there's a staff person, either a vice president or a vice chancellor that works with members of that committee. They talk to each other all the time. They get, you know, they're in our planning and construction area. They talk to that gentleman all the time about projects that are coming up, and they become very knowledgeable about it. But they understand that that's where the conversation ends, that it's not expanded beyond the committee. Then when the committee comes around, it's not unusual for a quorum of the board to be present, but those committee meetings, as Kavi advised, are in fact posted, and they continue to deliberate within those committees, but they don't, and sometimes they'll make recommendations to the board, sometimes they'll put something on a consent agenda, which again is fine because the meeting has in fact been posted. But you may certainly have those conversations. You may call your chancellor, you may call, depending on your structure, your vice chancellors and general counsel, your finance person, and so on. Let me mention one other thing that I think I'm detecting in your question is that if you're talking, are you a trustee or a regent?
I was president of the University of Wisconsin system.
Okay, because trustees, remember, are elected officials in this state, and I think that the same principle holds true there, and there may be an additional interest, and that is the interest of a constituency of voters, such as that would be. But if first of all, nobody's suggesting that you should and that you can't talk to each other at all, or that or even that to agree with both of you at the same time, or even that the rolling quorum question is not a close call. I think the law is clear on that, but not all conversation is prohibited.
You just have to be really careful that somehow you don't end up with a quorum having had that same conversation. Like I said, I know people who are doing that, where they say, I'm not going to talk to anybody, just because they don't want to be accused of this, they don't want to be, dragged through it, they don't want to be indicted and have to fight that. And so it's the safest position. But like I said, even I have a friend on the council, and we talk. We just always say, if you talk to anybody else about this, if they say yes, they say, all right, well, I won't talk to you about it then.
And hopefully, every institution puts together an agenda that is not only the items that are coming up for consideration, but a full-fledged explanation of those items, so that the explanation pretty well should answer most any question that an individual trustee or regent would have. That's the idea.
That's what we strive for.
Anything else? Real quickly, no other questions? Thank you, Mary.
Mary says no.
We'll stand adjourned.